Is there ever a scenario where the defense actually makes you a very, very good substantial offer, and now your attorney turns around and says, you know what? I am going to withdraw as your attorney. You want to know the answer? Come join me for a walk through the neighborhood as I share with you the answer to that question. I am Gerry Oginski, a New York medical malpractice and personal injury attorney. Yes, there is an instance where that could occur. So now, let's go back for a second. Let's imagine that you brought a lawsuit against a careless doctor claiming that he caused you significant harm and injury as a result of his malpractice. And now, during the course of the lawsuit, the defense tells you that they are never negotiating, they are never going to settle your case. So you are now resigned to the fact that you are going to have to go to trial in order to convince 6 members of the community, a jury, that you are slightly more likely right than wrong, that what you are claiming is true. And now, as you get closer to trial, one day your attorney calls you up out of the blue and says, listen, the defense has reevaluated your case, and now they have made a substantial settlement offer because they recognize the exposure and liability that they have. And in light of that, they have now offered something very, very significant. Your attorney tells you he has done tremendous research. Your attorney tells you he has analyzed similar cases to yours. Your lawyer tells you about the risks of rejecting their offer, as well as the risks of accepting the offer. You might not think there are, but yes, there are risks of accepting the offer, including regret, meaning you accept the defense's offer, and then weeks, months, or even years later, you turn around and say, you know what, I should have held out for more. That's regret. That is a risk of accepting the defense's offer. Okay, so how did we get to the scenario that I raised in the title of this video, where the attorney, your attorney, actually seeks to withdraw as your attorney in spite of this substantial settlement offer? I'll tell you how. In this discussion that you are having with your attorney about all of the risks associated with rejecting the defense's offer, and among them, that includes going to trial and risking the unknown, because no matter how good your case is, no matter how many experts you have supporting your particular case, no matter how great you believe your case is, and no matter what you think a jury's going to do, the reality is that nobody, not you, not your attorney, not the defense, not the doctor whom you've sued, nobody knows what the outcome of a jury trial will be. Nobody. The only time all of those people, all of you will know what the outcome will be is after you go to trial, and now the jury comes back with their verdict. That is the only time you are truly going to know what the jury has done. But before then, it is a complete unknown. So now it is always a risk to go to trial. And even though you may have the odds in your favor, during the course of trial, testimony may turn those odds upside down. The defense's experts may be so much better at trial than your experts. There could be so many things that happen. You might be caught in a little white lie that destroys your credibility and turns your case upside down. There could be many, many things that happen during the course of trial that totally reverse your opinion of what you originally thought. Your attorney now tells you he has done extensive research to determine what similar cases to yours have settled for, as well as what type of verdicts have been upheld at the appellate level for this type of injury. And now he's telling you what injuries you have and what he reasonably expects a jury to do in your particular case. And now he's weighing the risks of a settlement, which is a guaranteed amount of money that you will receive now, as opposed to the unknown of what's behind door number 1, or maybe door number 2, or even door number 3. A jury could rule in your favor, but give you substantially less than what you think your injuries are worth. A jury could rule in your favor and give you much more, which means the defense is going to appeal, and guess what? You've now bought yourself an appeal, and that will take another 1 to 2 years to resolve. Then, what's behind door number 3? Well, the jury could turn you away without a dime. That is also a possibility, despite the fact that you think you have a great case. So there are many variables and many options that go into evaluating the risks of this type of case. So now, getting back again to the title of this video, what could possibly go on that now your attorney says, listen, I have to withdraw, I have no choice? I'll tell you the scenario. Your attorney has recommended that you accept the defense's offer. And by the way, the offer that he's referring to is not the first offer. That was a lowball offer. And now, after a few days of extensive negotiations, your attorney tells you that he has received from the defense a fantastic settlement offer that he believes you should accept. He believes that a jury will not give you anywhere close to this amount of money, and this is a guaranteed amount right now that you will walk away with, a certain amount of money, and this is the best outcome you could possibly expect to achieve. You turn around and say, absolutely not. I'm going all the way with this case. I want a jury to come back and decide my fate. I don't care what happens. I want the jury to tell me whether or not I have a case and whether or not my injuries are worth what we claim they are. And the client, you, the client, are adamant. You refuse to listen to your attorney's advice. Your attorney winds up telling you over and over at length why it's so critically important, and based upon the legal research and based upon prior settlements and prior verdicts, that this is the best possible outcome you could achieve, and you simply disregard your attorney's advice. Your attorney says, listen, if we go to trial, I'm going to lose everything. I've already invested 2 years of my life into this case. I've spent a tremendous amount of money prosecuting this case out of my own pocket, and now I'm telling you, you should accept this, and you still refuse. So the attorney tells you, in that case, I'm going to have to move to withdraw. Now, that leaves you high and dry. That means you are now left without an attorney. And yes, you will then have to try and find another attorney to scramble to take over your case as you are quickly approaching trial. Is it possible you can find another attorney who's willing to do that? The answer is maybe yes, and then again, maybe no. So why do I share this quick information with you? I share it with you just to open your eyes and to help you understand how these types of cases work in the state of New York. You know, I recognize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you are thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.